Welcome into Mock Trial Masterclass, your guide to controlling the courtroom. I'm Luke, and this is the ultimate guide to mock trial basics. If you're just getting started in mock trial, whether that's in high school, middle school, college, law school, this is the video for you. I'm going to be showing you some of my favorite videos from the Mock Trial Masterclass channel that are going to help you get the best jump start on your career in mock trial. Today we're going to be starting with a talk that I give my incoming freshmen every single year, breaking down the 5 parts of every mock trial. It's going to show you exactly what to expect once competition season starts. And here we go. All right, pre-trial. This is the point in the trial where you'll see attorneys interacting with the judge and asking them some important questions about their preferences for the trial that's about to happen. You might see attorneys asking things like where the judge wants them to stand for various parts of the trial, if they need to stay at the podium or if they're allowed to have what we would call leave of the well, meaning just sort of free reign to move about the courtroom freely. You might hear them ask if they need to ask permission to approach witnesses or if they just have that permission and can approach witnesses freely throughout the trial. But the main point of pre-trial or preliminary matters is one thing, and that is to get everyone on the same page. You may run into some teams who look at pre-trial as an opportunity to show off their knowledge and stand up there and talk for 5 or 10 minutes. I can't stand that personally. I don't think it works. I don't think it's effective, and I don't think you need to. You can make a strong first impression simply by having a smile, by being comfortable and confident during pre-trial, and asking a couple of important questions, again, just to get everyone on the same page heading into the trial. Once you're through with pre-trial, you're ready for opening statements. An opening statement is exactly what it sounds like. It is a statement that opens the trial. The goal of an opening statement for both the plaintiff or prosecution and the defense is to preview the trial that's about to happen. You'll hear language in opening statements a lot of times like you will hear, the evidence will show, the facts will show, you're going to be convinced, right? These preview types of language, because that's exactly what an opening statement sets out to do. It sets out to preview the case. It does that by previewing the witnesses that you're going to hear from, the witnesses that your team is going to call. You do that by previewing the law, by explaining to the jury, hey, here's what the law is surrounding this case, and here's how you're going to see it play out today. And you also preview the case by just flat out telling the jury the story of the case. If it's a murder trial, you got to tell them the story of, Linda killed Bob, right? If it's a contract dispute that's made it all the way to a jury trial, you got to tell them the story of so-and-so signed a contract and didn't do what they said they were going to do, and now they need to pay up like the contract said they had to pay up. But again, opening statements for both sides, it's all about previewing the trial, telling the jury what to expect. Once opening statements are done, the prosecution or plaintiff will call their first witness, and with that witness, we'll have a direct examination. A direct examination is when a witness, who in mock trial usually is your own teammate, answers questions from their teammate attorney that are friendly to their side of the case. The questions during direct examination are open-ended questions that for the most part start with who, what, when, where, why, and how, and that let the witness sort of be the star of the show. A lot of times in a good direct examination, an attorney will almost fade into the background and just kind of keep the witness going and let them be the star of the show. That's what makes a great direct examination great. During direct examination, a good team will continue to tell a story because every witness, for the most part, has a story to tell about their involvement in the case. You might hear from a witness who is a sort of main character in the case. Maybe they're the victim. Maybe they're the defendant themselves. Or maybe in a lawsuit, they're the person who filed the lawsuit. You might hear from an eyewitness, someone who saw or noticed something important along the way, or an expert witness, someone with scientific or other important specialized knowledge that is going to give some sort of educated opinion to the jury to help provide extra context to the case and make it make more sense. But in that direct examination, again, a witness is dealing with an attorney who is most of the time their teammate and who is friendly to their side of the case. Once a witness goes through direct examination from their attorney, the other side gets up and gets to cross-examine them. Cross-examination is a complete 180 from direct examination because we're no longer dealing with an attorney and witness pair who are friendly to each other. In a mock trial context, we're now in cross dealing with an attorney and a witness who are opponents, who are not on the same team, and an attorney who, number one, is going to want to pull facts out of the witness that are not friendly to their case, and an attorney who's going to want to steal the show from the witness. Right, a second ago on direct examination, I talked about how the witness needs to be the star of the show. The exact opposite is true with cross-examination. In a good cross-examination, the attorney is going to steal the show. And instead of asking open-ended questions like who, what, when, where, why, and how, the attorney is going to ask very tight, very rhythmic, close-ended, or leading questions that point the witness to the answer that they want. And for the most part on cross-examination, a good attorney is only going to ask questions that, number one, they know the answer to for a fact, or number two, they don't care what the answer is. It's all about recontrolling the narrative after your witness has gone on in direct examination to talk about the things that help the other side and bringing them back and sort of reminding everyone of some facts that are going to help your side. If you want to watch an example of a great cross-examination, go to my film sessions playlist on the main channel page on the Mock Trial Masterclass YouTube channel. There's a really great cross-examination example that's going to help this make a lot more sense, along with great examples of pre-trial, opening statement, direct examination, and closing argument, which we're going to talk about in just 1 second. We've made it to the end. The last element of a trial is going to be closing argument. Now, whereas with opening statement, we made a statement, right? We previewed the trial. With closing argument, we're done with statements. We're to the point of arguing. Now, in opening statements, you're not even allowed to argue, but when we get to closing arguments, you need to make sure that that's all you're doing. A lot of times I see teams in closing arguments just kind of turn it into what I call second opening, where instead of giving a preview of the trial, they give a recap of the trial. This is not a recap, guys. A great closing argument is going to take all of the evidence that came out during a trial and put it all together and contextualize it all and be persuasive to the jury and sort of say, hey, remember what you heard today? Here's why that points to my side of the case being the one that you need to rule for. Again, closing argument. It's all about arguing. You're not making a second statement. We took care of that in opening. You're going to argue in a good closing argument. Both sides will do it. In a lot of cases, the plaintiff or prosecution will get a chance to have a rebuttal as the last word, and then you can take a deep breath because you're done. Now, like I mentioned a minute ago, this is a sort of 1,000-foot overview of how a mock trial works and how each part of a trial works. If you want to dig deeper, there's plenty of videos on my channel on each of these elements of a trial that you can dig deeper, learn more about, and figure out how to get better at them. You can also pick up a copy of my book. That's a great, probably the easiest way to dig into each of these even more. And I can't wait to hear about you getting started with your mock trial career as you continue to learn more about this stuff, and I hope start to win and do it a whole lot. Up next, I want to show you my video about what it takes to win a mock trial competition, but this video isn't about strategy in the sense of how to write the best opening or how to give the best cross-examination. The stuff I'm going to talk about in this video is more about you. It's more about the type of competitor, the type of character it takes to win competitions, and the type of team character that it takes to win competitions. Let me show you what I'm talking about. So the first thing that it takes to win a mock trial competition is confidence. You've got to be confident if you want to win a mock trial competition. If you've ever listened to this channel or read my book before, you know that I always say that the team who wins virtually every mock trial round is the team that did a better job of controlling the courtroom, right? Of making the room theirs, of taking control. So let me ask you a rhetorical question. How in the world do you think you would control the courtroom without confidence? And the answer is obviously you can't. You 100,000,000% have to be confident, have to exude confidence if you want to control the courtroom in mock trial. Now, I'm sure there are a lot of you listening to this who are thinking, well, gee, Luke, I'm more of an introvert, or I tend to be more of a shy person. Does that mean that I can't possibly succeed at mock trial? Absolutely not. I have seen plenty of introverts and people who aren't the most outgoing succeed at crazy high levels in mock trial. Because here's the thing about confidence in the courtroom. It's less about your personality and more about your preparation. I'm going to say that again because it's super, super important. Confidence in mock trial is less about your personality and more about your preparation. See, if you're stepping into a courtroom for the first time and you don't really know what you're doing, then nobody, introvert, extrovert, outgoing, more shy, and keep to yourself type, no one is going to be confident in that situation, because how could you be? You don't know what you're doing. But if you're prepared, if you've been watching a lot of these YouTube videos and studying how mock trial works, and you've read my book and you've been working with your coaches, then my guess is that confidence meter will start to tick up a little bit. And then once you've done some mock trial, once you've participated in it for a while and you've gotten some experience under your belt, then that confidence meter is going to keep going up, right? Because all of those things tie into your preparation, not your personality. And that's what counts when it comes to confidence. It's all about your preparation. And you veterans out there who might be watching this video, I want you to understand this too, because even if you've done a lot of mock trial, if you start to hit the brakes a little bit, you start to not work as hard on a particular case, and you don't prepare like maybe you used to because you think, well, I don't need to anymore, I'm experienced, that confidence meter, it's going to come back down. It's not going to be where it needs to be, and you're not going to be as confident as you need to be for your team to have success and control the courtroom like you need to. So the first thing you've got to have if you want to win mock trial competitions is confidence. The second thing you need to have if you want to win a mock trial competition is you've got to be a great teammate. Unless you're doing a one-on-one mock trial competition like Gladiator or Trial by Combat, mock trial is a team sport. And in a lot of situations, especially when you're working with a witness, you're directly interacting with your teammates. The success of your teammates is directly impacted by you. That's why it is super, super important for you as a mock trial competitor, as a mock trial master, to be a great teammate. Because here's the thing. You may be really, really great at mock trial. You may step into the courtroom and own it from moment one. But the reality is that you represent only 1 out of 6 people on your team that are going to be scored and evaluated over the course of a round. So doesn't it make sense that in addition to your performance being great, you should do everything within your power to make your teammates' performance great? Right? Of course. And so some of the things that's going to take is building good relationships with your teammates during practice. You don't have to be everybody's best friend, right? Not everybody's going to be everybody's best friend or get along with everyone on that level. But you do need to treat your teammates with kindness. And that means respecting them by the things you say to them, how you speak to them. And it's also the way you act at practice. Are you taking it seriously, or are you just kind of goofing off? Are you showing up consistently on time to practice and only running late when you really have to? Or is it just kind of something you don't really care about, and so you're not respecting your teammates' time and you're constantly showing up late, right? It requires you to be a great teammate to win mock trial competitions, and that means in preparation, like we were just talking about, and also means within the course of a mock trial round itself. Because when you're sitting there in a mock trial round, there's all sorts of things you can do to help out your teammates. You can be encouraging to them at counsel table, writing them an encouraging note or saying something encouraging to them after one of their performances. You can help them set up an easel if they're going to use an enlargement maybe, or if they're impeaching a witness and they're getting to the point where they're about to need the witness statement to give to the witness, you can have it ready to go for them and hand it to them, right? The mock trial teams that I have seen who excel and win state titles and win national titles, all of them have one thing in common, which is everyone on those teams was a great teammate. Not everyone loved being around each other, and not everyone wanted to hang out with everyone on the weekends, but they all served each other with class and with humility, and they were all great teammates. And if you want to succeed at mock trial, if you want to win at your next competition, that's exactly the attitude, that's exactly the approach that you'll need to have. All right, the third thing that it takes to win mock trial competitions is authenticity.
Now let's think about that word authentic for a second. I talk about this on my channel a lot, but authentic just means that something is real, right? If I say that I have an authentic Star Wars movie prop, that means I have a real Star Wars movie prop that was actually used in the Star Wars movies. If I say I have an authentic Billy Joel autograph, that means that I have an autograph that Billy Joel himself actually signed, right? It is real. So when I say that you need to be authentic as a mock trial competitor to win competitions and be a mock trial master, what I'm saying is that you need to be real. You need to be a real-like, anyway, version of whatever it is you're portraying, whether you're an attorney or a witness. Now, I understand that you're not real attorneys and that you're not actually the witness part you're playing, and you're never going to get there 100%. But you need to get as close as possible, because the teams that excel in mock trial and the individuals, competitors who excel in mock trial, are those that seem authentic. That means if you're a lawyer, you need to appear as a real-life lawyer. That takes into account how you dress. That takes into account the way that you speak, the commands you have of courtroom procedures and the rules of evidence, and just doing various parts of a trial well. If you're playing a witness, you need to look like a real version of that witness. If you're a police officer, you need to appear like a real police officer. Again, that's how you dress, that's how you speak. It's the type of content you're bringing to the table. If you're playing a doctor, you need to look and sound and act like a doctor. Whatever role you have within the course of a mock trial round, you've got to bring authenticity to the table. Way too often, I see people who treat mock trial almost like an acting performance, where they come into the trial room wearing a Halloween costume, or they start to say things like, well, in the mock trial universe, that a real-life lawyer would never ever think of saying. And it's my opinion, and it's really not just my opinion, because I've seen this play out in scores over and over again and in head-to-head competition, is it really detracts from your performance when you start to do stuff like that makes you seem inauthentic, that makes you seem, again, not like a real version of whatever it is you're tasked with playing. So, to be a mock trial master, to win mock trial competitions, it takes confidence. And again, confidence doesn't come from your personality, it comes from your preparation. Right? Confidence, number one. Number two is it takes being a great teammate, being there for your teammates before rounds, during rounds, and after rounds. And then number three, you've got to be authentic. You've got to seem real. You've got to appear as a real version of whatever role you're playing. If you can nail those three things and then pair them with other important strategies about succeeding and excelling in mock trial rounds, I know that you and your team will be on the way to winning and on the way to performing like mock trial masters. If you're about to be on a mock trial team for the first time, that probably means you're going to have to try out or audition. So in this next video, I want to show you my top tips for nailing your tryout or audition for this upcoming season. All right, let's hop in. My 5 things that I'm always looking for during tryouts at the beginning of the season. Number 1, and this is first for a reason because it's the absolute most important thing, confidence. I'm looking for confidence in new students above practically anything else. What I'm looking for is this student going to be really, really quiet and timid and kind of stiff and afraid to do anything? Or are they going to come in right from day one, this tryout, and be loud to where I can hear them, be completely unafraid to move around and use all their abilities? You know, that's what I'm looking for really more than anything else. Confidence is one of the key traits of mock trial masters. I talk about it on here all the time. I talk about it in my book. It really, really sets you apart on game day when you go to competitions. But I gotta say, it also really, really sets you apart in your tryouts. From experience, a lot of students come into their mock trial tryouts almost apologetic. They come up and they do their thing and, oh, I'm sorry, I don't know that well, and they're really quiet and you can't hear them. And it's like, why is this person even trying out? Do they even know how to do public speaking? Now, what I will say is I've seen a lot of people who had that kind of tryout progress over the years to the point where they became just absolute studs at mock trial. But if I'm looking at a tryout from a first-time student and I've got one that's oozing confidence and one that just seems really, really nervous and uncomfortable, which one do you think I'm going to go with for the role that's being handed out? Obviously, it's going to be the one who displays confidence. So Go be confident. I've got a video that I just made all about what confidence looks like in mock trial. I'll put a link to that in the description below. That's what you got to have first and foremost. Second thing I'm looking for is public speaking and acting skill. Notice I didn't say mock trial skill because I'm less interested in this tryout of do you know objections really well, do you know courtroom procedure really well. You're going to get there eventually. And while a baseline level is important, we'll talk about that more in a second, I'm not that concerned about you having this depth of knowledge about mock trial. What I am concerned about is, can you speak well in public, or if you're playing a witness, can you act well? So things that help lend to both of those things, first of all, confidence, like we talked about a minute ago. Volume really plays into that a lot, but also with your speaking, do you have a variety of tone? Are you monotone the whole time? Or do you get really excited and, oh, there's this big point, and now I'm going to break it down to this little thing, right? Do you have these advanced level public speaking skills? Do you have some natural talent in either one of those places? Are you a naturally compelling person to listen to, or frankly, are you kind of boring? Now, the good news is that those are areas where you can develop, where you can grow. So if you listen to that and went, gee, I kind of think I'm a boring speaker, I'm very nervous. You don't have to be a boring speaker. You're not resigned to that fate for all time. Go watch some great mock trial speakers. I've got a film sessions playlist where we watch some awesome opening statements and closing arguments together. Go watch one of those. Learn from those speakers. See what you can implement from their performances. Don't, be afraid to have volume. Don't be afraid to use movement to your advantage. The vocal variety that I was just talking about. Use pauses to your advantage too, right? All of this plays into your public speaking talent. And then with a witness, am I able to believe, even in this first tryout, that you are that character that you're playing? Have you taken some of the details we know about this character and integrated them into your performance? If this character says they're from Savannah, Georgia, and you're getting up talking in a British accent, I'm going to be very, very confused as to what is happening in that situation. But if you've been able to develop, a Savannah Southern accent, and that's going to be very compelling for me as a coach sitting there watching that. So, above all, just remember, you can develop this stuff. It's not all natural talent that you just wake up with, but it is something that I'm looking for, and it's something I think every coach is looking for. Do you have speaking talent? Do you have acting talent that we as coaches can coach you in the actual mock trial stuff and marry those two sides together to hopefully eventually in you create a top-notch performer? Next thing I'm looking for is your level of preparation. Do you know what you're doing? Now again, I don't need in-depth courtroom knowledge. I don't expect you to get up and have the rules of evidence memorized. But if I told you to give an opening statement, have you done enough to figure out what exactly that means? Or have you asked me for help and wanting to know what that means? Do you know what the difference between the plaintiff and the defense is? Right, that's the level of things I'm talking about. If you're sitting there watching this channel, my guess is you won't run into that problem because you're already invested, you're already studying, and that puts you so far ahead of the competition. But I have had students come into tryouts where it's like, do you even know how to tie a tie? Or did you even have someone else tie the tie for you? Can we at least start with that level? But if you come into the tryout and I get the sense that you've put no effort into this, that you have not prepared, you're kind of just reading something that you've written down that's not even that good, that you didn't try that hard at, I'm not going to be impressed by that, and no one is ever going to be impressed by that. Your level of preparation signals to your coach what they can expect out of you in the future. If you were lazy for this tryout that is deciding whether you're going to be on the team or off the team, then what am I supposed to expect that you're going to do once you're actually on the team? Whereas if you come into that tryout prepared, you know your stuff cold, it's not the greatest stuff in the world. You're not a mock trial superstar who knows everything about everything, but you put the work in, you have some level of courtroom procedural knowledge, and you've started on that track, I'm going to be really, really impressed and want you on my team. Fourth thing I'm looking for in tryouts is, can you make adjustments on the fly? A lot of times when we do our tryouts, we have our students go through the course of an actual trial, and I will be the judge. And sometimes I'll do things as the judge just to kind of force the students to think on their feet. And again, I recognize that these are newbies who don't have an in-depth level of mock trial knowledge. So that's not what I'm looking for. I'm not looking for, well, did they do the correct technical thing in that situation? What I'm looking for is when I gave them something they didn't expect, did they freak out and panic and completely melt to the ground? Or did they go, okay, let's try something else. Let's do something else. Even if I really don't know what I'm doing because I'm new at this, let's see what happens. That kind of goes back to confidence, what we were talking about at the beginning. But the big thing I'm looking for is, can you roll with the punches? Because the reality is, rolling with the punches is so much of what makes up a talented, successful mock trial competitor as an attorney or as a witness. So if you get thrown a curveball in your tryout of some kind, roll with the punches. Do your best. Do it with boldness and confidence. I promise your coach is less concerned about do you do the correct thing in response so much as you do something and you do it with some gusto. You do it with some boldness. That's at least what I look for, and it really sets apart a competitor who comes in for a tryout when they're able to nail that. All right, the fifth and final thing I'm looking for in mock trial tryouts when I watch them, when I'm making my decisions based on them, is what I would call archetypes. And what I mean by that is I'm oftentimes watching an attorney thinking to myself, what kind of attorney is this? Is this a highly intellectual attorney who I could see wind up doing expert directs? Is this someone who has a lot of personality that's going to really lean in and be great with character witnesses? I'm looking at it and saying, is this an opening statement attorney? Could this be a closing argument attorney? With witnesses, I'm looking and saying, is this someone I'm going to want playing a funny character? Is this someone I'm going to want playing a more dramatic character like a victim? Or is this someone who I could see more as an expert witness? I'm constantly thinking through those things watching tryouts because I'm always kind of vision casting and forward thinking with them. I'm much more concerned not about what's happening right now and what level of skill does this person have right now so much as based on their abilities, based on everything else we've already talked about in this video, what do I see their future being in mock trial? What kind of role do I see them fitting into? Now, a lot of times with this, my first impression is wrong. There have been plenty of times where I said, yeah, I think this person is going to be fill in the blank, and they wind up not being that and excelling at something else. But I will say a lot of the times those first instincts, those first impressions do turn out to be true, where I say, you know what, this person is going to be a great dramatic witness, and then a year down the road they're excelling at that part. Because at this point I've done this for a while. I kind of know what traits make for good performances at each of those positions, and that's just something that I am thinking through when I'm watching tryouts. But again, I'm thinking through all 5 of the things we went over in this list. And the good news is that outside of that 5th one, which is going to be more up to your coach's discretion, those first 4 things we looked at are things you can prepare for and get better at. Prepare. Don't come into your audition cold like you have no idea what's going on. Do some research. Watch some more mock trial masterclass videos on this channel. Gain a little bit of courtroom knowledge. Go in there with some confidence, right? Be bold, have some volume, be loud, control the courtroom as best you can as a first-time competitor. Roll with the punches, respond to what's going on in the moment. All of those things are going to help you take your tryout to the next level and separate yourself from the others that are trying out and hopefully get a spot on the team. So you've got a tryout coming up. Put this stuff into practice, and then please come back and leave a comment below or send me an email at luke@mocktrialmasterclass.com letting me know how this goes for you. I'd love nothing more than to hear your success stories, and I know that there will be success stories if you put this stuff into practice. Now, there's all types of evidence in mock trial. There's things that witnesses say from the witness stand, that counts as evidence. And then, of course, there's physical evidence, like in an extreme case, maybe a murder weapon, a knife, a gun, or in a less extreme case, maybe even a boring case, paperwork of some kind that might prove someone did or didn't do something. And knowing how to put that physical evidence into what's called the record in the course of a mock trial round is really, really important for beginners. So in this next video, I'm going to show you exactly how to do that. So in this video, what we're going to talk about is the steps that you need to go through to enter an exhibit into evidence. Because simply talking about an exhibit and saying, these phone records, you dealt with these phone records, right? if you don't actually do the steps we're about to talk about, the jury, when they go to deliberate the trial, if this were real life, wouldn't be able to take the documents with them, and you also wouldn't be able to give the jury the documents during the trial. But if you follow the steps that we're going to go through and put the exhibits into evidence the correct way, you can publish those exhibits to the jury. And again, if we thought of this as a real trial, they'd be able to take those exhibits with them to the deliberation room at the end of the trial. So, I hope you understand just how important it is to do this correctly. Ready to go? Let's do it. Step one to getting an exhibit into evidence is you got to help us understand what it is we're dealing with here. This comes before you even pull the piece of paper or the physical item out to give it to the witness. You got to ask some questions that lay the foundation for what we're even talking about. So for example, if we're talking about a cell phone record, you might ask the witness a few questions about that cell phone record in a general sense. You're not going to be able to get into the content of the cell phone record until after this process we're about to go over, but you at least want to introduce the cell phone record, again, with some general questions. Questions you might ask about a cell phone record for this stage of the process are, did you deal with any records with this person and their cell phone? Are you aware of any cell phone records that this person had? And do you see how those questions, again, don't get into the content of the records, don't ask any specific questions about the record. It just lets the witness establish that they know what we're talking about here, and it gets the jury's eyes and ears in tune with the fact that we're probably about to talk about a cell phone record. Everyone's on the same page, the communication is good, and that sets us up for step number two. Step number two is going to be pulling the piece of paper out and getting it to the witness. So, of course, I don't have to tell you how to do the first part, pull the piece of paper out. Now, getting it to the witness is a little bit more complicated because there's a few things you'll want to do. Very first thing you'll want to do is you'll want to ask the judge for permission to approach the witness and opposing counsel. Now, you'll want to be paying attention because some judges will tell you during preliminary matters that you don't need to ask for permission to approach the witness or opposing counsel. So just be sure you take a note of whatever the judge says during preliminary matters and follow that. But for this example, let's just pretend that the judge said you do need to ask for permission. And so that's what we'll start with. You'll look at the judge and you'll say, Your Honor, may I have permission to show opposing counsel this exhibit and then give it to the witness? And pretty much every time they will say yes. So what do you do next? Well, you take the exhibit and you walk over to opposing counsel and you show it to them. Now, notice I did not say you give it to them. You show it to them. You keep it in your hand firmly and you show it to them because all you're concerned with at this point is that the document is unmarked. This is mock trial, so both sides know what we're talking about here. Both sides have seen the document. There's no surprises. The other team doesn't need to sit there and waste your time by holding onto the document and reading it before giving you a little head nod telling you you're allowed to keep going. Control the courtroom, keep the document in your hand, show but don't give. After you've shown it to them, keep moving on in the process and give the document to the witness. The whole time you're doing this, you'll want to be announcing for the record what you're doing. If you don't know what the record is, it's basically like a transcript of a trial, and in real life, it's really, really important to have a record that includes all the facts. So in mock trial, we want to do the same thing by, as we're showing opposing counsel, saying for the record, maybe let the record reflect that I'm showing opposing counsel a clear and unmarked copy of whatever exhibit. And then as we walk to the witness, we might say, and let the record also reflect that I'm now handing that exhibit to the witness. It's a little bit clunky at this point, and it's probably the hardest part of the whole process. But trust me, if you just do this the way I told you, and you just memorize those phrases, you'll be A-okay. So we've introduced the exhibit in the sense of telling us what's coming, right? Or is there a phone record? Are you aware of any phone records, right? Okay, we know that's coming. Now we've shown it to opposing counsel. We've given it to the witness. It's time for us to figure out what in the world is this thing. And that's exactly what you're going to ask the witness. Okay, maybe you don't quite look at the witness and say, hey, what in the world is this thing? But you are going to ask them this question. Could you please tell us what I have just handed you? And the witness may say Exhibit H, if there's a letter on it. And if that's what they say, you're going to want them to explain what is Exhibit H. We don't just want to use a letter. We want everyone to be on the same page with what we're talking about. So if the witness says, well, this is Exhibit H, you can say, and what is Exhibit H? And the witness is going to say, well, Exhibit H is phone records for XYZ person. Now, there's one more question you'll want to ask the witness before you actually put the document into evidence. You'll want to ask the witness, is this a fair and accurate copy of the exhibit? And the witness is going to answer yes. And then once you do that, you're ready for the final step. The final step of the process is the easiest. You'll look at the judge and you'll say, Your Honor, we offer exhibit whatever into evidence. And that's it. Now, you might get an objection and you'll have to deal with that. And if you do have to deal with an objection, don't worry. I've got videos on objections that you can go and look at on the Mock Trial Masterclass channel to learn a little bit more about how to do those well. But in terms of the actual process of putting an exhibit into evidence, that's it. It's a little bit confusing the first couple of times you do it, but the more you work through this process, the more you start to understand why we do the various things that we do as a part of this process, and the more it starts to become second nature. So what at first might seem a little bit confusing and overwhelming, and you're having to do a lot of memorization, by the end will be very second nature, and you'll be able to do it very easily, and you'll be doing it like a mock trial master. Finally, I want to talk about something that not a lot of competitors think about, even though you should, and that's what to wear in a mock trial competition. Now, what I promise you is I'm not going to be telling you to go out and get the finest tailored suit or anything that's going to cost you a whole lot of money, but you do need to be intentional about your wardrobe choices, whether you're an attorney or a witness in mock trial, and this video is going to cover how to nail it. All right, let's start out with just a general rule for everyone. Don't dress like you're going to prom, right? That's going to cut out 90% of the problem with attire in mock trial. That means no hot pink ties. That means no evening gowns. You also don't want to dress like you're about to attend a fraternity or sorority event. So no navy blazers with gold buttons, no khaki pants, no boat shoes, right? That's the kind of stuff we want to avoid. Now that that's out of the way, let's talk about what we don't want to avoid. Let's talk about what we want to wear, starting with male attorneys. As a male attorney, and again, this is stuff I followed when I competed, you're going to want to wear a suit that is either dark blue, navy, black, or gray, with a white or blue shirt and a non-distracting necktie or bow tie. And what I mean by non-distracting is, again, you don't want any very bright colors. You don't want a Winnie the Pooh or Looney Tunes tie, right? Something maybe a solid color, maybe a regimental striped tie, just something that is obviously to you going to be non-distracting. We also don't want bolo ties for our male attorneys. And also, just a general rule, the color of your shoes should match the color of your belt, and it tends to be best to go with brown or black shoes and belt. Make sense? Let's move on to the ladies. What tends to work best for female attorneys in mock trial is actually very similar to what works best for the men in mock trial, and that is to wear a black, gray, navy, or dark blue suit with a blue or white shirt. Now, you're obviously not going to wear a tie, but where you do have a little bit of a choice here is whether you want to wear a pantsuit or a skirt suit. Both work just fine. The choice there is up to you. But another warning for both male and female attorneys is that what you want to avoid is color coordination. I've run into teams before that color coordinate across their attorneys, like in their school colors, or they're all wearing the same like American flag pin or something like that. We don't want any of that. That kind of gets into corny, hokey territory. Just you do you on that. There's no need to have matching or coordination. So that covers our basis on attorneys. Let's wrap up by talking about what witnesses should and should not wear. So in the same way that an attorney doesn't want to look like they're about to go to prom or to a fraternity or sorority event, as a witness, you don't want to look like you're about to go trick-or-treating on Halloween, right? The whole Halloween costume witnesses, I'm not a fan of. If you want to get a very realistic looking costume that has a distinct purpose, I'm okay with that. But overall, here's what you need to keep in mind as far as your attire goes as a witness. You need to think about the part you're playing and wear what that type of person would wear in real life. So for example, if you're playing the defendant in a murder trial, you need to wear a suit and tie because that's what a defendant in a murder trial would wear. If you're playing a doctor, you do not need to come into the courtroom with a lab coat and latex gloves on that have blood on them and a stethoscope, right? Because in what scenario is a doctor going to be treating a patient and go, oh crap, I got to go to court and run out and have all that stuff still on, right? That's Halloween costume territory. What a doctor's probably going to wear in court is something a little more formal. Maybe a shirt like the one I have on right now, which is a button down with a collar, but probably tucked in, unlike me right now, with a belt and with nice shoes and nice pants. Maybe a coat on over it and maybe even a tie. But they're not going to be wearing a lab coat and latex gloves, right? That's silly. Okay, someone who's a bit more of a zany character. They're probably going to not be wearing jeans and a t-shirt, but you got to think, what would this character, if it were real life, think was appropriate to wear in court? And so what would this zany character I'm playing think of as their nice kind of Sunday best attire, right? You can get creative within that. But overall, the rule to remember when you're thinking of how to dress as a witness is dress as your character would dress in real life. So that kind of covers the basics of what to wear in mock trial. If you have any questions, let me know in the comments. And again, I know that this seems really nitpicky. I know it seems like something that's not that big of a deal, but it is a big deal because a team that walks into the room dressed for success screams to their opponent and to the scorers that we're ready to control this courtroom. And if you're underdressed, if you look like you're about to go to a sorority event, if you're wearing boat shoes and khakis, it's going to have the opposite effect. Now, this is all just a starting point. So if you want to dive even deeper, if you want to get more knowledge about how to succeed in mock trial, pick up a copy of my book, Mock Trial Masterclass, because that's the best next place to go. This book is going to get a lot more strategic than anything that we covered today. It's going to tell you how to write good openings and good closings, how to perform well as a witness. And if you want to pick up a copy, you can click the link in the description on YouTube or in the show notes on podcast platforms. But that's it for today. You have graduated from Mock Trial Basics. Be sure to explore the rest of the Mock Trial Masterclass channel to learn plenty of other things about how to succeed in mock trial.